Hi, my name is Rachel, and I will be discussing the Squamish Nation housing project in Vancouver, BC. In the late 19th century, 80 acres of land in Vancouver was declared a reserve for the Squamish Nation. In 1913, the Squamish people were forcibly removed from the reserve. In 2002, the British Columbia Court of Appeal ruled to return 11.7 acres to the Squamish Nation. The current plan is to build a 3,000 housing unit project. The impact of this project is to generate revenue and include low-income housing for the Squamish Nation. The picture on the right is of a thunderbird and is of great significance to the Squamish Nation. The bird looking down shows that it is looking over the people. The wings show it is watching over the sea creatures. The crest indicates that it is both male and female. The three tail feathers represent past, present, and future, and the lizard in the talons represents Temla, or the blood of the earth or cedar trees. I'm going to now go over the historical context. The Squamish Nation has resided in Vancouver's Kitsilano neighborhood for thousands of years. In the late 19th century, about 80 acres of land was declared a reserve for the Squamish peoples. Gradually, the land was parceled off by leases to third parties such as the CPR. In 1913, the Squamish Nation was forced to accept a settlement and forcibly transported by barge to North Vancouver, as shown in the picture. By 1965, all of the original reserve had been sold by the federal government to third parties. This is a plan from 1934 found in the archives of the City of Vancouver, shown as the Crown's plan to parcel off sections A, B, and C of the reserve. The circled triangle is a large section of the reserve that was later returned. This document shows the Crown granted the CPR this land in 1902. I will now go over the legal court proceedings. In 1977, the Squamish Nation filed a lawsuit against the federal government. According to historical Squamish Nation documents, their reserve lands were unjustly taken. In 2000, the Squamish Nation voted for a $92.5 million land claim settlement, returning 11.7 acres of the former reserve land. The yellow triangle is the area of land that was returned to the Squamish Nation. The trial judge found that the Canadian Pacific lands should be reverted to Canada and held as reserve lands for the use and benefit of the Squamish Nation. These findings were appealed by both Canadian Pacific and Canada. The BC Court of Appeal dismissed both of these appeals, and in 2002, the Kitsilano Indian Reserve No. 6 was established. I will now cover the legal background to both the removal and return of the reserve lands. In 1763, King George III issued the Royal Proclamation. Among other declarations, it outlawed the acquisition of Aboriginal lands unless they were first ceded to the Crown. This was intended to provide a basis upon which to negotiate treaties and was an expression of a nation-to-nation relationship between the British Crown and Aboriginal peoples. The Royal Proclamation is critical to this case as the unlawful selling of land is at the heart of this case. In 1867, Canada's first constitution was written. At the time, it was called the British North America Act. Most relevant is Section 91(24), which grants federal jurisdiction over Indians and lands reserved for Indians. This essentially functioned to deny sovereignty and right to self-determination for Aboriginal peoples and relegated them as wards of the state. In 1876, the Indian Act was passed. This passing was made possible by the provisions in Section 91(24) of the Constitution. The goal of the Indian Act was the enfranchisement of Aboriginal peoples. Enfranchisement is the loss of status as an Aboriginal person. This results in the loss of both the right to community and nation membership. The government's goal of enfranchisement was to eliminate Aboriginal peoples as distinct groups and force Euro-Canadian society on Aboriginal peoples. As you can see from the quote by the Department of Indian Affairs at the time, they were publicly and strongly pushing for the assimilation of Aboriginal peoples. In 1911, the Oliver Act was passed. This was an amendment to the Indian Act which allowed municipalities and companies to take sections of reserves without legal surrender. This was later amended to allow judges to relocate an entire reserve from a municipality if it was deemed expedient. The man shown is Frank Oliver, the Minister of Interior Affairs at the time, who used this amendment heavily throughout the prairies. In 1973, the Calder decision was the first case to recognize Aboriginal land rights. The Supreme Court ruled that the Aboriginal title existed at the time of the Royal Proclamation in 1763. This was the first time the Canadian legal system acknowledged the existence of Aboriginal title to land and that such title existed outside of, and not just from, colonial law. The Calder case is named for the Nisga'a chief Frank Calder, shown here. The Nisga'a Nation did not win their case. However, it did pave the way for the federal government's comprehensive land claims system and encouraged the federal government to negotiate with Aboriginal groups that had not signed treaties. In 1982, Prime Minister Trudeau repatriated the Canadian Constitution. This constitution includes the Charter of Rights and Freedoms, among other important pieces of legislation. The original draft made no mention of Aboriginal rights, spurring large-scale protests throughout Canada and forcing the government to see that such inclusion was necessary. As a result, Section 35 was added to the Constitution. Section 35 of the Constitution provides that the existing Aboriginal and treaty rights of the Aboriginal peoples of Canada are hereby recognized and affirmed. This provision protects both Aboriginal and treaty rights. Aboriginal rights find their source in the pre-existence of Aboriginal societies on the North American continent. Treaty rights find their source in the signed agreements between the Crown and Aboriginal peoples. As well, treaty rights include land claim agreements. There are two fundamental constitutional principles included in Section 35: honor of the Crown and fiduciary relationship. Honor of the Crown refers to the fact that the Crown is presumed to be honorable and intends to fulfill its promises and obligations. Importantly, this is only engaged whenever Section 35 applies, and not during all interactions between the Crown and Aboriginal peoples. A fiduciary relationship refers to the fact that the Crown must put Aboriginal interests ahead of its own. In 1996, R.V. Badger resulted in the determination of four main principles that are protected by Section 35 of the Constitution. These principles include that a treaty is a solemn exchange of promises between the Crown and various Indian nations. There is to be no sharp dealing between the Crown and Aboriginal peoples. Ambiguities must be resolved in favor of the Aboriginal party, and the onus of providing treaty right extinguished lies with the Crown. In 2000, the Nisga'a Final Agreement was reached. The Nisga'a were the first Aboriginal peoples to hold land in fee simple. Fee simple means that land is privately owned by the First Nation. This means that the nation has absolute right to dispose of land at will. In 2010, Canada officially adopted the United Nations Declaration on the Rights of Indigenous Peoples. Article 10 and 32 are most relevant to this case. Article 10 states that no Indigenous people should be forcibly removed from their lands or territories. No relocation may take place without free, prior, and informed consent of the Indigenous peoples. Article 32 states the right of Indigenous peoples to determine and develop priorities for land and resource development. It is yet to be determined to what extent Canada's adoption will affect domestic legal decisions. Previously, in cases where there was ambiguity, Canada's endorsement of international, but not legally binding commitments have been relevant in the interpretation of domestic law. There are two forms of Aboriginal lands in Canada: reserve lands and Aboriginal title lands. Reserve lands are lands held by the Crown for the use and benefit of the Aboriginal peoples for which they were set apart. These lands are governed by the Indian Act and treaties. Reserves that serve as residences are referred to as Indian bands or First Nations. Lastly, only status Indians may own land on a reserve, and that ownership remains at the discretion of the federal government. An example is seen in this case study, Kitsilano Reserve No. 6 for the Squamish Nation. Aboriginal title lands are significantly different. Title refers to inherent Aboriginal right to land or territory. This right is not granted from an external source, but rather is a result of Aboriginal people's own occupation of and relationship with their home territories. In areas where no treaties were signed, Aboriginal title was not extinguished, and these peoples still have ownership and jurisdiction over these lands. Importantly, with a few exceptions, no treaties were signed in BC. Aboriginal title was first shown in Calder v. British Columbia. The Squamish Nation plans to build a 3,000 housing unit project. The development will be primarily rental property to generate revenue. However, there will also be some affordable units for Squamish Nation members. As the Kitsilano Reserve is in an urban setting, there is no potential to generate income from resource development. As such, real estate is the only source of potential revenue. As well, of the 4,000 Squamish Nation members, 1,100 are currently on a waiting list for housing. Thus, the affordable units have great potential to significantly improve access to housing for members. The reserve land belongs to the Squamish Nation, therefore the Squamish Nation has full jurisdiction over land usage. Further, the Squamish Nation has no need to consult with the city and local community due to its designation as a reserve. However, they have chosen to maintain communication with Vancouver about all current plans. The next steps for the Squamish Nation are to bring the land designation amendment and business terms to a vote for the nation. Shown here is the current Squamish Nation Band Council.